Hello there and welcome again to the Employment Law Show. John Scholes here alongside Lior Samfiru, employment lawyer, Samfiru, Tumarkin, LLP, the most positively reviewed law firm in the country. We got another show for you full of information you're going to want to learn. You have very good and robust employment law rights, workplace rights, but if you don't know about them, you can't take advantage. That's why we peel back the layers of the onion every week on the show and involve you in the show through email and our radio show as well to learn lots about what you should know, because you go to work every day, 5 days a week. It's where you spend most of your time, so you need to be educated, right? I will give you the information right off the top, how to reach Lior and his team. Phone number 1-855-821-5900. help@employmentlawyer.ca is the email address. And this website, which we're going to use and refer to several times during the show, it's called pocketemploymentlawyer.ca. It's free, it's anonymous, and it will give you access to the Severance calculator, which over 2 million of us in this country have used. The Severance calculator at pocketemploymentlawyer.ca. What you should know about termination for cause. That is coming up here in just a bit. But Lior, we always talk about the case of the day or the week that was, or whatever title we want to give it. Something that's been that you've been working on from your desk, pal. What do you got?
Well, John, always great to be here and to talk about employment law. And what has been happening in my office is I get asked a lot of questions every single week from people that watch this show. And when they watch the show, they realize, wait a second, I have rights, I have entitlements. And they call me because they want to follow up. And that's exactly the point on this show. You may not understand or appreciate all the rights that you have as an employee. Well, I'm here to tell you those rights are substantial. You have really good rights in this country as an employee. And on this show, as John says, we peel the onion. We tell you what you need to know. We arm you with that knowledge. It's like being armed. It's being powerful when you have that knowledge, whether it's because you lost your job and you want to understand your rights. Maybe you're being mistreated by your boss. Maybe you're being discriminated against, or the job that you used to have is no longer the job that you have now. Well, what do you do? What do you say? Can that even happen? We tackle those things and many others on the show every week. And if you want to follow up with me, if you want to talk privately or have a private email exchange, we'll give you that contact information throughout the show. I encourage you to do that. Don't be bashful. I want you to do that. Now, that said, let's get going. Let's talk about a situation that came across my desk, John. So this particular gentleman that I spoke with, he had been working for his employer for just under 2.5 months. Now, he was hired in a very senior role to manage a team of employees. The employer went through an extensive search and eventually hired him. Well, it became very clear that the management style of this individual didn't really coincide with what the company expected. Liked him, he was a good guy, but the company just felt that he wasn't a good fit. So after about 2.5 months, just shy of 3 months, they called him into a meeting and they said, unfortunately, we have to part ways. And we wish you all the best. We're even going to be nice to you. We're going to pay you 2 weeks of severance, and we're going to say goodbye. Well, this person called me, as he should, as you should as well, if any of this rings a bell to you. And he really wanted to know, is this right? They let me go. I was in a senior role. They offered me 2 weeks' pay. Is there anything else that I'm owed? So let's be very clear. Even though he worked there for 2.5 months only, even though his employer may have thought he was on probation. Remember, probation is not automatic. You have to sign an employment agreement that says you're on probation in order to be on probation. So for this gentleman, because of his senior role and because he's been there only for 2.5 months, he was still owed as much as 6 months severance. Now, you heard me correct. He only worked for 2.5 months, and yes, he's owed 6 months severance. Short service employees are treated better than longer service employees, and at least disproportionately better. And of course, the fact that he's in a senior role means it's maybe going to be more difficult for him to find another job. So the lessons here are very, very important. Number one, probation is not automatic. I've said that already. Number two, just because you worked for a company for a short period of time, a few months, a year or two, does not mean you don't get your full severance. Does not mean that your severance is not going to be substantial. It's going to be substantial. The length of severance can even be greater than the length of employment. That's why you do the right thing. That's why you contact me if you lose your job, even if you only work for a short period of time.
You know, it's interesting, those two factors you mentioned about the length of time versus the severance being longer, and then also the fact that he had a senior position being a CEO. That's a moving target when you're calculating severance, isn't it? I mean, someone who works at a coffee shop who's been there for 2 years may also get 6 months as opposed to this guy who worked for a couple months, but he's a CEO, so it's going to be tougher, I guess, for him to find a gig, right?
Generally speaking, the more senior a position, the greater the entitlements, but there's all those factors that we have to consider. The person's age as well, the availability of other jobs, which is why I'm here to tell you that it's not as simple as saying, well, I worked for this amount of time, therefore I get this amount of severance. Those factors can impact your severance up or down in a significant way. So don't make assumptions. Chances are, whatever you think you're actually owed by way of severance, you're owed a lot more.
It's interesting, too, because usually when we talk about fiduciaries and CEOs, when they're out getting jobs or receiving jobs, they're not usually on Indeed shopping the resume around. They're usually pulled from other places. So they're reduced, I think is what you guys referred to it. Does that also increase? Can that increase how much severance if you're let go shortly into being pulled away from a job you otherwise loved, right?
Absolutely. One of the main factors that can impact severance is whether you were recruited from another job. Yeah, we do call that induced. So if you're working for a company for a number of years, you get recruited to go to another company, and things don't work out, they let you go, well, you're going to be owed enhanced severance that recognizes your service with the previous company. So you may have only had a year with the new company, but maybe you had 20 years with the previous company. Now, for calculating your severance, you may be a 21-year employee, meaning you could be owed as much as 2 years worth of severance. So this is reason 2045 as to why it's so important to get legal advice if you lose your job.
And that same goes for a term contract if you're let go before the fulfillment of that contract, correct?
The general rule is if you're on a fixed term contract, a contract for a specific period of time, and you're let go before the end of the contract, you have to still get paid the balance of the contract. So if there's 15 months left on the contract and you're let go, you still have to get paid for those 15 months. So very important to keep that in mind.
Okay, guys, employmentlawyer.ca. That is a good website to go to anytime. Lots to be learned. There's contact information there as well. You can also go to the media section and find past episodes of this TV show and our radio show, which Lior and I pretty much host across the country. Just about. We almost have full coverage across this entire country of ours. But either way, you can find a radio station close to you that does carry the radio show. The beauty is there's always a number for you to call in live and talk to us. And we cherry pick some of those phone calls we get during the week. We play them back here and we talk about them. So our first phone call from one of our radio shows coming up right now.
So a question regarding about my company recently issued a new contract. I've been working here 11 years as a truck driver. What it is, all this time they've been paying me as a contractor, company equipment, company fuel, company maintenance, but now they're going to put us on a payroll. The only thing I have problem is that my 11 years of service is not in the new contract.
The old contractor position, eh?
John, this happens so often with truck drivers. They're being called contractors when in fact they really are employees. And I want to be very clear. If you work for one company as a truck driver, you're likely going to be considered an employee of that company. Okay? The law makes that determination, and you don't get to decide. I don't get to decide. The company you work for doesn't get to decide. The law makes that decision for us. If you work for one company and you do what they say, you take the loads that they tell you as a truck driver, you are their employee, even though they may say you're a contractor. Now, in this particular situation, company says, yeah, okay, well, we'll have you sign a new agreement, but we're going to say that we're not recognizing your past service. Very bad idea. You don't want to give up that past service. Why? Because if they let you go at some point, now you're going to get less severance because you've agreed to delete that past service. That difference can be major. So how much service could he be giving up, or how much severance could he be giving up if he signs that agreement? Well, to do that, let's go and use our handy tool at pocketemploymentlawyer.ca. We're going to use our severance calculator. So he's telling us he's been there for 11 years as a truck driver. If, in fact, you were to lose his job now, because he has that 11 years, you can see on the screen he'd be owed as much as 14 months of severance. 14 months. That's a lot. Now, if he signs an agreement that gives up on those 11 years, he could be looking at a fraction of that. And why would he ever want to walk away from those entitlements? So don't sign an agreement that gives away your service, that's going to cost you money. And remember, chances are, if you work for one company, chances are you're an employee of that company, perhaps who has been misclassified as a contractor.
Super important too, because you and I both have spoken to truck drivers who go through these contracts all the time. Some of these guys are like 10, 15, 30-year employees. These guys work their whole lives doing this gig, so it's super important that they know this stuff. You could be giving up on tens of thousands of dollars of severance.
Yeah, I think you remember we recently did a radio show, and one of our callers said that he's been with that same company since 1982.
82, yeah.
Right? That's 40 somewhat years. But the company says he's a contractor. Nonsense. Can you imagine?
Practically the owner.
How can you more be of an employee? How more of an employee can you be if you work there for 40 years? But that's important, because if and when his position is going to end, because he's not a contractor, he's going to get his full severance. There's no world where you can work for a company for that long and not be an employee.
In addition to the radio show, which we just mentioned, the TV show as well, Lior does a lot of live streaming on Facebook and YouTube and LinkedIn. You can catch those and join in at ST Lawyers anytime, at ST Lawyers to join the live stream. Want to get to a question, first one for the show. Lior says, I've been on the receiving end of many comments from coworkers and a manager about my impending retirement. I have no plans to retire in the immediate future. Can I be forced out of my job?
Yeah, and there's two issues here. Number one, kind of the easy one to answer, is that no, you cannot be forced to retire. There's no mandatory retirement. You cannot be told to retire whether you're 65 or 85 or any other age. It's only your decision. And an employer that lets you go because of your age is committing a very serious human rights violation. So right off the bat, that's illegal. But it's more interesting than that. An employer that keeps suggesting that you should be retiring, an employer that kind of gives you a nudge and say, maybe you're better off not being here, maybe we should do a youth movement, that in itself is a human rights violation. By telling you that you're too old, or you're suggesting that it's time for you to be gone and retire, that alone is discrimination and a human rights violation. So what I would tell this person is, tell your employer in writing that you're not comfortable with this and you wish to be left alone and not discuss retirement with anyone. If they still don't do that, if they don't back off and they continue harassing you, well, then guess what? That could be a constructive dismissal, a human rights violation. The compensation would be owed. It's unacceptable to press the issue of retirement with any employee.
We've talked about this before, and I know in the past you've had people, like a particular client of yours had, the boss is kind of leaving golf resort pamphlets, great place if you retire. Just saying, have a look at that. That's brutal.
I'm not saying, I'm just saying. Yeah, exactly. But it's brutal, and you and I may joke about that. It could be funny, but it's not funny for that individual who just wants to work. He doesn't want to be told that he's too old. He doesn't want to be told that he doesn't have any value. Completely unacceptable.
Coming up here, guys, what you should know about for-cause terminations. That after a short break on the other side. In the meantime, here's the number always to reach out to Lior and his team, 1-855-821-5900, help@employmentlawyer.ca. We'll continue. Lots more of the Employment Law shows coming up. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. And welcome back. Thanks so much for hanging out through that short break. We are back here on the Employment Law Show. John Scholes, Lior Samfiru, reaching out anytime. You're always encouraged to do so, right? The phone number, 1-855-821-5900, help@employmentlawyer.ca. As mentioned, today's main topic on the show, what you should know about for-cause terminations. Let's roll into this. A for-cause termination is considered the capital punishment of employment law. You've said that before.
It is very important, and that's just not me saying that. Some of our top judges in this country have made that comment. It's the death penalty. It's the capital punishment of the employment relationship. There's nothing worse that an employer can do to an employee than to fire them for cause. But because of that, because it's the capital punishment, just like with capital punishment, it's reserved for the worst offenders. It's not a punishment that you get just because you did something wrong, or even because you did a few things wrong. You get that punishment if you've committed such a sin that there's just nothing else that an employer can do with you. So what we want to talk about here is how employers may get this wrong and really when termination for cause happens. But I always want you to keep this capital punishment analogy in your mind. And if your employer lets you go for cause, or if you think you've committed some sort of a workplace misconduct, ask yourself, am I deserving of the worst punishment? Is there anything else that the employer can do, such as a warning, even a suspension? If there is, then they're expected to do that. They cannot fire you for cause in that situation. Terminating for cause, always, always very difficult.
Talking for cause terminations here, the segment of the show. Number 2 is this. It is extremely difficult, as you mentioned, for an employer to legitimately fire someone for cause.
So it's difficult, number one, because, as I said, you're entitled to get a lot of other types of discipline before an employer can terminate you for cause. It's not enough that you did something bad. It's a very high standard. Remember, capital punishment. But it's more than that. An employer is expected to build up a case before it terminates you for cause. The employer is generally not allowed to go from zero, from nothing, all the way to a termination for cause unless there's things in between. What I mean by that is an employer can start off by saying, okay, here's a warning, and then maybe a second warning, and perhaps then a final warning. And if still the situation continues, then and only then can the employer continue or consider terminating employment for cause. It's difficult to do that. An employer that doesn't put in the time, that doesn't build its case to terminate for cause, would have wrongfully dismissed an employee. And by the way, one of the reasons why we're talking about this termination for cause is that if the company legitimately terminates you for cause, they don't have to pay severance. So that's the issue here. Termination for cause, no severance. A termination without cause, you get your full severance. So you only get deprived that full severance. Number one, you did something bad, something terrible. Number two, the company built its case to get to that point, and they didn't just get there right away.
Something else they could do, another weapon they have in their toolkit, as you mentioned, Lior, is the bad performance review. But you've got to speak out if you disagree with that bad performance review, right?
So often when a company gives you a bad performance review or puts you on a performance improvement plan, what that is one of the steps that they're using to try to build the case for a termination for cause. So what's important here is this. Don't make it easier on the company to build that case. If you're given a negative or a bad performance review, if you don't agree with it, well, say so. Say so in writing. Send an email to your boss or whoever the right person is and say, well, you gave me this negative performance review. Here's some information that you need to have. Here's why I don't actually fully agree with it. Put that information there. Be professional, be respectful. Don't accuse anyone of anything, but give them the facts. By doing that, you're essentially eliminating the company's ability to build a case against you, to try to fire you for cause, and that's very important. Your silence, you're staying silent in the face of a negative performance review is exactly the same as you saying, I agree with it. And if you agree with it, you're going to make it that much easier for the company to let you go for cause.
Again, this segment of the show, we're talking about what you need to know about for cause terminations. This may confuse some people. We got to get to it, and that is you are likely still owed full severance pay if you're dismissed with cause.
Well, here's the thing, because a company may often say to you, we have cause. They put that in writing and they say, here's all the reasons why we have cause. So we're not going to pay you any severance. And you may think, well, they know and I did something wrong, so I'm not going to get any severance. Not so fast. For all the reasons that I've said before, it's difficult to terminate for cause. It's the capital punishment. Company has to build a case to get there. The vast majority of times when the company alleges that they have cause, it's not cause. It doesn't rise to that level. And that means you're owed your full severance. The other thing I want you to keep in mind is cause is either you have it completely at 100% or you don't have it at all. There's nothing in between. Either you have it or you don't. So a company that has 95% cause, it's as if they have zero. It doesn't exist. So most of the time, when you're let go for cause, and I've been doing this a long time, I've seen this thousands of times, the company doesn't actually have cause. They still owe you your full severance. They may not realize that even. They may think that they have a right to do that. In most cases, they don't. That's why it's so vital, so important to call if you're let go with or without cause.
Our fifth and final point today on termination for cause. This is where the money is, like literally you need to and should have an employment lawyer like Lior review any termination papers before you put pen to paper. Absolutely.
Well, we talked already about severance and the fact that if you're let go supposedly for cause, okay, if you sign off on that piece of paper, you're walking away from the severance you could be owed, and that could be as much as 2 years' pay. But there's other things that we need to deal with. For example, a record of employment. If your company, the company you work for terminates you for cause, they're likely going to give you a record of employment that says that. And that means you get deprived from getting EI. You're not going to qualify for EI. Well, wait a second. Don't sign off agreeing to that, because we should be able to get you a new record of employment that specifically says, no, there isn't cause. You can get EI and you can get severance. So that's why it's absolutely vital, especially if you have, if the company says they have cause, to not sign off on any offer that you've been given, not sign off on that severance letter. Once you do, you walk away from entitlements, and those can be huge.
As we talked about earlier in the show, employmentlawyer.ca, the place to go if you want to find a radio station near you that carries our weekly show, generally an hour long in most markets. We always can ask you to contribute to the show and call in with your questions. It's great to sit and listen and learn, but when you ask questions, you're answering them, or at least asking them for thousands of other people across your province or country, so feel free to do that anytime. Full call number 2 from one of our radio shows is coming up right now.
My husband injured his shoulder, and he had to take a month off work and go to physio and try and get it better. So then he wants to go back to work and see if he can manage. The doctor just put in a few accommodations. The lawyer, they can't accommodate him because they take someone off what they're doing to help my husband.
Yep, heard that story before, right? Yeah.
Yeah.
Can't accommodate, won't accommodate.
Won't accommodate, can't accommodate, it's too difficult to accommodate. Well, none of that matters, John. The reason for that is an employer has that legal obligation to provide accommodation. Yes, in some situations it's not easy. In some situations it can cost the company money and create a bit of a headache for them to accommodate someone's limitations. It doesn't matter. The law says you have to find a way to accommodate, even if difficult, even if costly. What you need to trigger that accommodation is a doctor's note, okay? A doctor's note saying, here's the accommodation you need, or here's what your limitations are. It's not good enough for you to say, employer, these are my limitations. You need a doctor to say that. But once a doctor says that and puts that in writing, the onus then shifts to the employer to provide that accommodation, to make that happen. And if they don't, that's a human rights violation. Now, in some situations, of course, it may be so difficult, so costly to accommodate, and yes, the company doesn't have to go quite that far. But John, I've seen this many times, just like with this call that we just played, that the company just doesn't work hard enough. They don't try. They say, well, it's too much of a headache, so I don't want to do it. Illegal, human rights violation. If you find that your employer does that, they won't accommodate you, you have your doctor's note, you're asking for modified duty or modified hours, company's not giving it to you, let me know. Oftentimes, just them hearing from me changes things right away. They'll respond very differently to me. But don't accept your employer refusing to accommodate you.
We love our phone calls from the radio shows on this show. I want to get to one more, but we got to take a short break first, and we'll get back into that for sure. In the meanwhile, stand by for that. And the phone number to reach Lior and the team, 1-855-821-5900. Email, send those along anytime. Help at employmentlawyer.ca. We'll continue. This is the Employment Law Show. Hang on. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. And welcome back. This is the Employment Law Show. Our phone calls come via our radio shows, which we've been doing for 10 years. We're at the 10-year mark already. How about that? A decade of talking on air. We love it. You want to catch a radio show? employmentlawyer.ca. The media page will take you to a station nearby you where you can tune in and call in and join us possibly on this show as well. Phone call number 3 for the day. Lior's coming up right now.
I'm calling for my son. He was working here in a small restaurant for about 6 years. The company was sold. All the employees were let go. Old owner said that there was going to be a smooth transition, that the new owner was going to be getting in contact with them, but nothing.
He hasn't received any severance?
No.
So, John, whenever a business is sold, if you lose your job as a result of that sale, then yes, you are owed severance. Now, the new buyer, the new owner of the company, is not legally required to take on the employees. It's between the buyer and the seller to decide what happens there. But the new owner is not required to take you on if there's a sale of a business. But if they don't take you on and you lose your job, the seller owes you your full severance. And by the way, I've seen with restaurants often, you want to act on that quickly. You don't want the owner of the restaurant to take the money from the sale and disappear, and then we can't find them. But in this situation, because this person sold their business that they worked for sold, the restaurant sold, they did not have a job with the buyer, they lost their job, of course, severance has to be paid. It must be paid. There's no exceptions for restaurant owners. So, of course, the question now becomes, as usual, how much severance? You know what I'm going to do. I'm going to go back to pocketemploymentlawyer.ca and use our severance calculator to see just how much severance this person is owed. So 6-year employee at a restaurant, in his 20s, you see on the screen there he's owed easily 6 months severance. It could even be even more than that. 6 months severance. He got no severance. He's been wrongfully dismissed. That's why we use our Pocket Employment Lawyer tool. You can do that as well, by the way, if you lost your job, if you're worried about losing your job, if you're just curious, check out that severance calculator. You'll be glad you did.
I will give you one more website you can use anytime called terminationquestions.com. You do exactly that. Go to the website, ask your questions. May appear on a future show. We'll get to one for this show, Lior. Goes like this: as we recently hired new staff, and my hours seem to have been reduced dramatically as a result. While I previously worked 30 hours a week consistently, I now have to request more shifts. Do I have to accept this as I am a part-time employee?
Very important question, because some people think, well, because they've classified me as part-time, they can do whatever they want to my hours. Nonsense. Doesn't matter what they call you. What matters is what the terms of your employment are. If you've been hired as a part-time employee and you always work 25 or 30 hours a week, well, your employer can't just change that. They can't say, well, now you're only going to work 10 hours. That would be a constructive dismissal. So in this situation, this person went from 30 to getting a lot less. So they have the option to accept that new reality, and now they're going to work what they're going to work, or they can say, no, I'm not accepting that. You've changed the terms of my employment. That is a constructive dismissal. I'm going to leave and make you pay me severance. But I wanted to remind everyone here that just because you have the title of part-time employee doesn't mean your employer can do whatever you want, whatever it wants, to your hours, to your pay, to your shifts. Absolutely not. Your terms are fixed, and if they're changed, that could be a constructive dismissal. And yes, part-time employees still get full severance.
The interesting thing, I think, in that note was consistently. I worked 30 hours consistently. Now, sometimes if this person was hired from the get-go way back whenever it was, and they went, 10 hours, 20 hours, 4 hours. If it was like that from the start, then they really wouldn't have any ground to stand on, right?
The question, of course, always is what are the terms of employment? If the terms of your employment is 1 week you work 5 hours, next week you work 25, and it changes based on your employer's discretion, then that's fine. But if you consistently work a similar schedule, a similar number of hours, that cannot be changed. Your employer cannot just decide to do that. So the reality is your terms should be fixed at the time you're hired.
So part-timers get severance, full-timers get severance, and salary people get severance.
And independent contractors get severance. Bottom line, if you had a job and you lost that job, you get severance.
That is pretty much it for another show. Thank you so much for your contributions. If you came from the radio station, we love you. You can always tune in. Go to employmentlawyer.ca. And you want to reach out to Lior any other time, it is 1-855-821-5900. Again, 1-855-821-5900. Email is help@employmentlawyer.ca. And don't forget that website. Keep it on your favorites, pocketemploymentlawyer.ca. Free, anonymous, and access to the severance calculator as well. Thank you so much for joining us here in the Employment Law Show. Come back next time. We'll do it all over again.